to this fifth lecture, the lecture series celebrating the 40th anniversary of the CISG. I am José Angel Estrela Faria, Principal Legal Officer with UNCITRAL, and today it will be my pleasure to introduce to you the work of UNCITRAL in the era of transport law. We'll be addressing carriage of goods by sea and comparing the legal regime for carriage of goods by sea with the carriage of goods by other modes of transportation. We also have a guest speaker, Professor Alexander von Ziegler from the University of Zürich, who will be addressing in particular the relationship between the contract of carriage and the contract of sale and the possibility for the possessor of the bill of lading to stop goods in transit and gives instructions to the carrier under the contract of sale. Now, the presentation of the legal principles governing carriage of goods, in particular as they relate to the liability of the carrier for loss or damage, is an area of the law that is particularly intricate because each mode of transportation has its own regime. And it is important for the understanding of this era of the law to look back at history, how this regime evolved, because only the awareness of the origins of the various rules allows us to understand the fundamental difference that exists in the liability regimes between carriage by sea, air, road, or rail, and to understand also how the current multimodal liability system works. So I will do this in two parts. The first part will be addressing the evolution of the law on the carriage of carrier's liability. Then we'll be listening to the presentation, the lecture by Professor von Ziegler on relationship between carriage and the contract of sales. And then we do an overview of the current liability regime. Before that, it is also important to, again, bear in mind the structure of international trade. We saw in two lectures the sales contract as it is treated under the UN Convention on Contract for International Sale of Goods, the CISG. Then we also examined the letter of credit transactions that support the performance of the obligations of the buyer to pay the price, and how that allows for an efficient allocation of risk in the performance of contract of sale. And today we'll be seeing the third main contract related to the performance of international sales, that is the contract of carriage, that is essential to ensure the performance of the seller's obligation to deliver the goods to the buyer. So the structure, as we know, is one where we take a starting point, the contract of sale, the relationship between seller and buyer. Then the buyer addresses a bank to obtain a letter of credit to the benefit of the seller. And the seller only obtains payment of the price once it delivers to the bank the proof that it has deliver the goods to the carrier according to the requirements and produce the documents required under the letter of credit. And this is the diagram that we can see here. Now, but to understand also the modalities for sea carriage and the differences between the main regimes, one being one regulated through international conventions and the other being a regime largely based on party autonomy, it's also important for us to put carriage of goods in its trade context. And here we have an image from the WTO World Trade Statistic Review 2019 and showing what the largest economies in the world by trade volume. And the largest economies are here presented in red. They're followed by economies presented in violet, and then comes light blue and dark blue. What is obvious from this picture is that the largest economies, and they are here North America, Europe, continental Europe, and also the United Kingdom and China, they are not linked by a contiguous land stripe. So the carriage of goods between them is bound to be by sea. So that's why sea carriage represents the largest portion of carriage of goods internationally. So the modes of transportation that we currently use include ocean carriage, short sea carriage, and that would be typically a carriage that is done across the Mediterranean, across the Baltic Sea, and across the Channel Islands. Air transportation, obviously, to connect different continents, railway, road, and increasingly combined or multimodal transportation. These are the various modes of transportation we'll be focusing on. What is also important to understand beyond the pure geography is also important to understand the structure of this trade, because as we will see, different types of commodities are typically transported, carried internationally using different legal arrangements for carriage. And if you take the statistics, they're more recent ones, but unfortunately UNCTAD doesn't present them in such a nice shape as we have. Here you can see that the largest portion, single portion of goods carried internationally is crude oil by value 17%. That is followed by containerized goods, minor bulks, and then iron ore, coal, and other dry commodities, and then other products. What does it mean for our understanding of carriage of goods by sea is that most carriage worldwide is carriage of commodities. And as you'll see, carriage of commodities is normally done by a different arrangement as carriage of containerized goods, which are typically manufactured goods that are shipped in containers. Another element of both industry and geography that is important for us to bear in mind is where most carriage of goods takes place. And most of it is in the Trans-Pacific routes or between Eastern Asia and Europe passing through the Suez Channel or on the North Atlantic Ocean. This is where most carriage of goods by sea take place. I stress this because when we talk about transport documents, we see that the area in which they are transported has a bearing on the type of documents that the parties use for transportation. We saw in the lecture about bills of lading and letter of credit that parties can use negotiable documents, and there are also non-negotiable documents, even for carriage of goods by sea. And in North Atlantic trade, parties choose primarily to use non-negotiable Seaway bills for carrying goods. Whereas in the Trans-Pacific or in the Pacific Europe trade, bills of lading are still very largely used in international trade. But what is also important to understand now on the structure of the industries is that we have on carriage of goods by sea, we deal with basically two main industries. One is called tramp trade and the other is called liner trade. Tramp trade is the hiring of a ship for time or for voyage by a contract called a charter party. That contract is not subject to any international mandatory convention. Here is an area of the law that is dominated by party autonomy. There are industry standards, there are practices, but there is not a mandatory law applying to the charter party contract. It is mainly used for carrying dry and wet bulk commodities. It is on-demand transportation in a highly competitive market. Lloyd's of London quotes every day the price for chartering vessels around the world. And it is a negotiated contract under its own terms. There are many modalities. You may charter by time, you may charter a ship by voyage, you may charter a ship bareboat, meaning empty, you may charter a ship with a cruise, or you may also charter a space on a ship under an arrangement called a volume contract. It is a negotiated contract in a highly competitive market, and it's also adaptable to your needs. Private companies, large companies often have their own terminals, be that in a harbor, be that in their own factories. And if you're chartering a ship, the ship can come straight to your transport terminal, to your slot in that harbor and pick up the goods there, and you can determine exactly where that voyage would take place. Opposite to that is the so-called liner trade. These are ships that follow an established route. That's why we call it a liner trade, because these are lines of transportation with a regular schedule of departure and arrival. So it's port-to-port carriage, operated by a carrier, is not your own crew, is the crew that the carrier hires for that liner. Is typically the carriage chosen for containerized cargo, what we call general cargo. That is manufactured goods typically. You can also, obviously can also carry other things stuff a container with other things, but it's typically, most of the container trade is manufactured goods in liner trade. Often a carrier would enter into contracts with several cargo owners. Typically, in the old days, there would be an announcement in the harbor. Nowadays, there are easier ways of finding that out. But a carrier would, when this industry started operating this model, a carrier would arrive. We are sailing from Bombay to Liverpool next Wednesday. And then the cargo owners would show up and contact the carrier to reserve space for carrying their goods. So typically a large container ship would be carrying goods from a large number of different shippers. It is a high market, it's a market characterized by a very high concentration or even an oligopoly structure. Whereas the tramp trade, you have any company that buys ships can offer them on the market, and even if you don't buy a ship, if you happen to own a ship, you can also offer it in the market. The liner trade is one that is dominated by a certain number of large companies, and especially after the most national navigation lines were privatized in the course of the 80s and 90s. This market has suffered an even bigger and deeper concentration in the hands of a few very large players worldwide that ensure these regular routes. In addition to it being an oligopoly market, is a market that is characterized by the use of very highly standardized contracts. The bill of lading, which is the contract typically used for carriage of goods by sea in liner trade, is typically a standard document, is a contract of adhesion. That means that the shipper does not negotiate the terms of the bill of lading. The shipper accepts the terms of the bill of lading. And normally the shipper doesn't even negotiate the freight to be paid. The freight is also fixed by the carrier. And in olden days, until recently, the carriers used to fix their freight in a trust. And there was even an exception given from antitrust rules in favor of the maritime industry to allow the carriers to establish their price by agreement among themselves. It's a very unusual arrangement that survived in Europe until way into the 21st century and was only abolished not very long ago. So it is an oligopoly, standard terms, fixed price, fixed dates of departure, fixed dates of arrival. That's the basic structure of this trade. Now, what are the parties involved in the contract of carriage? We have the carrier that undertakes to carry the goods from one place to the other against the payment of freight. it's not necessarily the owner or the operator of the ship, maybe a different person. And nowadays you may have a so-called non-vessel operating carrier who is a freight forwarder with whom we negotiate the contract, but actually hires then another carrier to perform specific legs of that transportation. We have the shipper, who is typically the seller under the sales contract. The shipper is the party that enters to the contract of carriage with the carrier, typically to the benefit of another party who is the buyer under the sales contract, and under the contract of carriage is called the consignee. So you see the terminology is not identical to the terminology under the sales contract. Under the carriage contract, we talk about the consignee as the party to whom the goods are to be delivered. So it's the party who is entitled to claim delivery from the carrier. In addition to that, we have then other parties outside the contract that play a role in carriage. They include the freight forwarders, the party that arranges the carrier and prepares and processes customs papers and other documentations. You have the marine insurer, and here we have basically two types of insurance. You have the insurance bought by the ship owners, and is basically a mutual insurance that is paid by the ship owners themselves, called the protection and indemnity insurance, P&I, the so-called P&I clubs. Most of them are based in London, and this is a self-insurance scheme of the carriers that protects them from loss of cargo, but also from damage to the ship and other liability to which they would have to compensate. And then you have the marine cargo insurers. And this is insurance that is bought by the parties to the sale contract, typically to top up the insurance that is not covered by the P&I insurance. Basically, that portion of the damage for which the carrier would not be liable. And you'll see in a moment that may be a significant portion for which the carrier is not liable. Then you have the operational parts of the transaction. They have the stevedores that manage the loading and unloading of the cargo, and often are also an entity that operates an entire transport terminal in the harbor, and then the warehouses where the goods are stored, and which is an operation which is not necessarily covered under the contract of carriage. As you see, it's a rather complex operation involving a large number of parties. What are the sources of law governing carriage of goods by sea, domestically and international? Domestically, we have maritime law and commercial codes. Typically, you will have in a domestic commercial code, and in the civil law systems, you would have a chapter dealing with carriage of goods and with the contract of carriage. And that regulates then the obligations between the carrier and the shipper. And you also have provisions governing charter parties. And actually, you would find even in old codes provisions on charter party. That is the contract for a freightment of an entire ship. Typically, these provisions under domestic law would cover both domestic and international carriage. Most legal regimes don't distinguish. Some do, but this is not necessarily the case. Many countries do not distinguish domestic from international carriage. Then we have a number of international conventions governing carriage of goods. They would apply only for carriage that takes place between countries that have ratified those conventions. And what is typical to all these conventions is that they only apply to carriage that is documented by a transport document. So a carriage that would, for instance, would be done only under a charter party and is not documented by a transport document would typically not be covered by an international convention. But you may well issue an individual bill of lading for portions of goods that are carried under a charter party, and then those goods represented by that particular bill of lading would fall under the relevant international regime. Now, I mentioned at the beginning that understanding the evolution of the law of carriage of goods is essential for us to understand the current status of the law. And that is because of two factors. One is that the rules on liability of the carrier, in particular of the carrier by sea, differ substantially from the liability rules for breach of contract under general contract law. And this is historically explainable, understandable through the evolution of the law in this area. The second reason is that different modes of transportation are subject to different regimes internationally, and each of them was adopted at a certain point in time and reflects the reality of the industry at that point in time. And you see that there are significant differences primarily between carriage by road and rail and air initially, but that over time air came closer to carriage by land, by road and rail, but that there are still significant differences between those regimes and carriage by sea. And all those we can understand looking back at history, how the regime, especially for carriage by sea, evolved. So, what are the general rules of liability for breach of contract under most legal systems? What I need to do is, if a promisor breaches a contract, I, as a promisee, what I have to do is to prove first the damage, second causation, and third, depending on the system, I would have to prove the fault of the promisor, or in other words, that the breach of contract resulted from the fault of the promisor. Some legal systems would presume fault, other legal systems would require a proof of fault. But these are the basic elements for contract liability in most legal systems around the world. Now, the carrier's contractual liability evolved from the beginning under stricter terms. When we examined the Bill of Lading, its evolution, we heard the concept of receptum nautarum being this old Roman law instrument or document that proved the receipt of the goods by the carrier. And since those days, the basic rule for a carrier under the traditional law, classical law, was the carrier had a duty to deliver the goods under the same conditions as it had received them. So that if the goods were damaged at destination, or if the carrier delivers less quantity than it had received, the carrier was presumed to be in fault and in breach of contract and was liable for the difference and for the discrepancy. This is the basic rule from which carriage of goods evolved. The exceptions recognized by law, and I'm not talking about yesterday's law, this goes back very, very, very long in time, goes back fundamentally to Roman law, was that to offset the harshness of the liability rule on the carrier was exempted from a liability for so-called acts of God, an impediment beyond the carrier's control, to use the terminology of Article 79 of the CISG, or inherent defect of the goods. For example, if the shipper delivers corn that is not sufficiently dry to withstand the sea carriage, and at the port of destination, most of the corn develops mold and is therefore non-edible, then the carrier is relieved of liability because this is an inherent defect of those goods for which the carrier cannot be held liable. With time, as carriage evolved and became more and more regularized in trade, carriers then started using the possibility recognized by the law in most countries to limit their liability for certain types of losses, or to exclude liability for certain types of losses. And in some legal systems, it was even possible for the carrier to exclude liability for its own fault. Some legal systems do not admit that possibility. Other legal systems do admit that possibility if the contract is a negotiated contract. And before liner trade developed, all contracts of carriage were negotiated contracts. So this was basically the status of the law around the end of the 18th, beginning of the 19th century. You had a harsh rule on the carrier, with the exception for circumstances beyond the carrier's control, compounded with the possibility for the carrier to contractually limit or exclude that liability. Obviously, since the liability was the default, right? And the carriers are being exposed to a large liability. It became quite common to include exculpatory or limitation clauses in bills of lading around the world, with the consequence that in those legal systems where this was acceptable, a carrier could basically exclude nearly all liability for anything that happens to the goods. This situation became a matter of great concern for shippers and cargo owners around the mid-19th century with the development of regular shipping lines and liner trade. Because by then the carriers could use standard terms, and also because that was the point in time when the so-called liner conferences were first negotiated among shipping companies. What were the liner conferences? Liner conferences are basically a trust among ship owners to establish dates of carriage, to limit capacity, to avoid overcapacity, because overcapacity would lead to a price war and would then lead to pressure on the freight prices and to pressure down the prices. So basically, those shipping companies operating, say, the sailing between Liverpool and New York would sit together and decide what is the optimum volume of availability for shipping between Liverpool and New York in each given time of the year. What would be the price that they will all be charging, and to avoid predatory competition among shipping companies, they would all agree on the price, and no one would be then charging a lower price. The existence of this structure also made it possible for carriers then to standardize the terms of contract. And by doing that, it also, one of the first things that was standardized were the liability clauses and the waivers of liability in bills of lading. So that by the mid to the late 19th century, all clauses were standard. And basically what the carriers did is that they would be looking at each other's waiver clauses and say, oh, it didn't occur to me to exclude liability for this one as well. So they put in my bills of lading. And so at the end, you had this very long list of exclusion of liability. This was the state of the law in the second half of the 19th century. It was a state of the law that was found highly unsatisfactory by the cargo owners. The only limitation to the possibility of excluding liability was, and recognized under English law at that point in time, was the so-called warranty of seaworthiness. This is a theory of English law that says a contract of carriage obviously is a contract, is a freely negotiable, but one thing is a bare minimum of this contract, and if this is not given, the contract is null and void. And that is that the carrier must provide a warranty that the ship will survive the voyage and that the ship is fit for carrying the goods. So if the carrier loads the goods in a ship that is unsuitable for that voyage and the ship goes down, the carrier is fully liable and will not be allowed to invoke any limitation of liability. That's called the warranty of seaworthiness. If the carrier provides that, then everything else is fine and the carrier would always be able to rely on limitation of liability. This situation caused enormous dissatisfaction in the United States at that point in time. The United States was not a maritime nation in the 19th century. The United States was an importer, a buyer of shipping services, mainly from England, but also from some other continental European countries. And American courts are very sympathetic to the cargo owners. And they considered that they had no reason for protecting ship owners to the detriment of the owners of the cargo. And American cargo owners would be going to court to claim for damage of goods, and the ship owners would invoke the bills of lading and all those exculpatory clauses. And at the beginning, American courts would be upholding that, but with time, the dissatisfaction grew and grew and grew, and the United States courts started then using the warranty of the theory of warranty of seaworthiness, find ways of declaring null and void certain waivers of liability, beginning with the waiver of liability for the carrier's own fault, which was considered to be unconscionable, and that those clauses were excluded. And then the courts also started being more careful in examining exactly the conditions of the ship and finding unseaworthiness in many aspects so as to give the cargo owners some compensation and a way to avoid those clauses. That led, in the United States, to a legislation that was called the Harter Act, which basically attempted to establish a compromise between the interests of ship owners and cargo owners. And the basic attempt of the basic equilibrium and balance of the Harter Act was to impose on carriers a certain number of duties that the carrier needed to perform that the carrier could not waive, related essentially to the condition of the ship and seaworthiness, right? To recognize a limited number of circumstances that would exclude the liability of the carrier, such as acts of God or inherent default of the goods or fault of the shipper, and a few others. We'll see what they are in the second part of today's lecture. And if the carrier had performed those duties, right, but could not invoke any of these exonerations because the damage was caused by a different circumstance, then the carrier would be liable, but only to a certain amount per piece. So a monetary ceiling for the liability of the carrier, right? So rather than being liable for the full amount, the full value of the goods, the Harter Act established this principle of a limitation of liability. So that's the basic structure. The Harter Act was, however, drafted in a way that provided clear obligations for the carrier, not just an obligation of best effort. And in an attempt to avoid the Harter Act being copied worldwide, that is a tendency that began in the beginning of the 20th century, but some of the dominions of the UK, such as Australia, Canada, immediately started legislating in the same fashion as the Harter Act. There was a strong movement by the international shipping companies to develop a convention to preempt divergent legislation around the world, and the result was what we currently know as the Hague Rules. The Hague Rules is actually a convention that was not adopted in The Hague, was adopted in Brussels in 1924. So that's formally it's the Brussels Convention, but it's known as the Hague Rules because there was a previous draft that had been developed in The Hague. Until today, we call it the Hague Rules. This is the base of liability, still in force in most countries around the world. And the current liability regime for carriage of goods by sea is one that's also characterized by a fairly high degree of fragmentation. You have 68 states in which the original version of the Hague Rules as per 1924 is in force, the original version, original text. 23 states, that's mainly in Europe, but a few other countries in the world, where the revised version of 1968 is in force. And I'll say in a moment what exactly changed between 24 and 68, but it's an amendment and a modernization of the old regime. And then 22 states that ratified a protocol of 1979. That protocol concerns only the monetary scene for limitation of liability, which is something that will be seen at the end of today's lecture. Then we have a second regime, which is in force in 34 countries, including this one, Austria. Austria has ratified the so-called Hamburg Rules. The Hamburg Rules were adopted at the diplomatic conference in Hamburg in 1978. The reason for developing the Hamburg Rules was the dissatisfaction of the non-maritime nations with the current regime, which they found to be too favorable to the ship owners to the detriment of the cargo owners. And this is also what is not surprising, that a countries deprived of a merchant marine such as Austria have ratified this one, and some neighboring countries here also have ratified the Hamburg Rules, whereas countries that have a merchant fleet still prefer the Hague or the Hague-Visby rules. But still, that's the second regime in force in 34 countries. And as an attempt to bridge the gap between the two of them, in 2008, the UN, which had developed the Hamburg Rules, then developed the so-called Rotterdam Rules that try to be a compromise between these two groups, but also does much more. Is not only dealing primarily with liability. The Rotterdam Rules also deal with documentary aspects of the contract of carriage, deals with the value of annotation of the bill of lading, deals with electronics bills of lading. It's a much more detailed instrument. This is also why it's a much larger instrument, and why it takes much longer for it to attract the sufficient number of ratifications to enter into force. Then we have one international convention for carriage of goods by air, and it is now in its third version. The original version was the Warsaw Convention, 1929, amended at The Hague in 1955, and then replaced by the Montreal Convention in 1999. That, you see, is much more uniform regime is enforced in 114 countries in the world. And whereas the Warsaw Convention, the regional, was ratified by 152. So one of the reasons that explains this uniformity is that this treaty is administered by International Civil Aviation Organization, ICAO, which is part of the United Nations system and has a specific mandate for civil aviation, and it promotes the uniformity in this area. Then we have one particular convention for carriage of goods by rail within continental Europe. There is also one in the convention for these former socialist countries of Eastern Europe and other Asian countries, but this is the one that is that mobilizes, that carries most of international trade by carriage by goods by rail. The so-called Simcoe Convention of 1950, it's enforced in 50 states, so that's mainly continental Europe and contiguous countries. And the same geographic scope, more or less, is the geographic scope of the Convention on Contract for the International Carriage of Goods by Road, the so-called CMR Convention of 1956, with 55 countries. So, to recapitulate, before now we take a break and listen to Professor von Ziegler's lecture on the relationship between the carriage of goods by sea and the contract of sale. We're facing a regime that is fragmented, in particular as concerns the type of carriage that is prevalent for world trade, which is carriage of goods by sea. The carriage of goods by sea is also fragmented not only because we have one regime that evolved over time but was not always ratified by the same number of countries in the later additions, but also because we have other parallel regimes, and one that differs substantially from the carriage of goods by air, road, and rail. But also you have one entire area of that trade that is subject only to party autonomy and is not governed by any international convention. So with that, if we have any questions on this part, yes, please. Yes?
My question is a set reason. We talked about this right now between the two parties, the shipper and the carrier. My question is, are there any exemptions or are there rules in this contract or in these law regimes? Who is responsible or liable against third parties? Because right now, I don't know if you know it, that the coast of Trinidad and Tobago is a huge oil spill.
Yeah, the question is whether are there any rules concerning third-party liability for carriage of goods and accidents that happen at that. And you mentioned an example, an oil leak in Trinidad and Tobago. That is a completely separate regime. There are international conventions about, including nuclear liability for nuclear damage and other, and oil pollution, the conventions that deal with liability for that. Those are conventions that are administered by the International Maritime Organization, IMO, and do not relate to the liability for carriage of goods, because though that cause of liability is tort liability, is liability of the carrier to whoever for damage caused by the ship, right? And can also damage that is caused to another ship by collision, can be damage caused to the environment, you name it, several causes of liability. These conventions and the regime of carriage of goods by sea is concerned strictly with the liability of the carrier to the shipper or consignee for loss or damage to the good. So it's only confined to the boundaries of the contract of carriage. So if there's a way of avoiding the limitation of liability, we'll talk about that in the second part. Yes, there is a way of doing so if the carrier wantonly and grossly breaches the obligations that apply to the carrier at the beginning or during the voyage. We'll see that in a minute. But apart from that, the liability limits are in most cases unbreakable. So,
is it similar to the London Convention? Is it similar to the London?
Yes.
So my question would be on the fixed pricing in liner trades. You mentioned that there was a shift in the legal construct, as to say, only recently. What was the reason for that shift? Was that a change in the underlying rules? Was that trade usage and customs, or how did that?
Yeah, the question concerns the introduction of competition in setting freights in the liner industry, and the reasons for that. The reasons for that is that I try to be brief because it's a long story and there's a lot of politics behind it. But merchant fleets were up to the 19th century also national fleets and state fleets in many countries in the world, if not all of them. Most countries had a national fleet. Part of the merchant marine was owned by the state, and they were favored by the state. And the states protected carriage under their own flag, right? And states supported their merchant fleet by allowing the merchant fleet to set freights and to negotiate on the terms of condition. And there was even an international treaty negotiated under the auspices of the United Nations Conference on Trade and Development, UNCTAD, called the Code of Conduct for Liner Conferences. And nearly the entire world had ratified that, including countries that are with a very strong competition policy and culture, such as the United States, but also Europe. That code of conduct was in Europe implemented by a regulation issued by the then European Community. Now, the structure of that industry changed radically in the course of the 90s through privatization in most countries. In most countries, the merchant fleet was inefficient and government started selling it. And at a certain point, there was no justification anymore for maintaining a system which most cargo owners had always complained as being very inefficient and leading to very expensive freight rates. The downside, of course, is that the moment that happened, the moment the large companies started leaving the conferences, then the less efficient merchant marines in the world went bankrupt because they couldn't put up with the competition with the more efficient ones. So you see there are various factors and forces that play into that, but eventually then this was completely abandoned. Nothing similar had existed for other modes of transportation. It was only for maritime transportation. Yes?
We talked about the warranty of seaworthiness.
Yes.
And that carrier would get liable if it was not seaworthy. But I just imagined a situation where the ship isn't seaworthy, but the concrete reason why the goods get damaged is an act of God.
Yeah.
Would then the carrier also be liable, or would the seller be the loss?
The question concerns the relationship between the warranty of seaworthiness and an act of God, and if you have a concurrence of causes to the damage. We'll see that and when we talk concretely about the exclusion of liability, right? There are two ways of looking into this, and you have to see what is the prevalent cause of the damage. Courts would have more sympathy for the ship owner and tend to think that if there is a proof of unseaworthiness, that would exclude the carrier's right to rely on an act of God to exclude liability. But it's a causation issue, essentially. It's not one that we have a clear-cut rule. One last question?
Yeah, so my question is the following. I have heard about the existence of two different insurance. It's shipment insurance, insurance of indemnity, and the other insurance between buyer and the seller, like as they agree. sum of coverage or just different cases?
Okay, the question is about the reason for the existence of two types of insurance, the classical marine commercial insurance and the P&I, or protection and indemnity insurance. Again, as I mentioned, the P&I is a mutual insurance mechanism of ship owners. The ship owners themselves paid into a mutual fund that covers the insurance risk faced by them. P&I clubs offer coverage against various types of risks. It's not only cargo damage. The P&I clubs can also cover damage to the ship. They can also cover third-party liability and various other types of liability. For cargo, however, the P&I clubs would cover only what the carrier under the mandatory law is obliged to pay. And as we will see, that obligation to pay is limited to a certain amount, either per volume or piece of goods or per weight of the goods. And depending on the instrument, the amount will be different. Now, meaning that at the end of the day, in case of loss of goods, if the carrier is liable to pay, and the carrier may actually even benefit from a waiver of liability, in which case the carrier would pay nothing, right? But even if the carrier is liable to pay, the carrier would pay only up to the liability limit established by mandatory law. That may be way below the value of the goods. So if you have goods that are valuable 5,000 euro, and the carrier is only liable to pay up to 600, then the difference, if you want to be fully insured, you have to buy commercial insurance to cover that difference. And that's why the two types of insurance still exist. So, but mainly the commercial insurance would typically cover only loss or damage to the goods. The P&Is offer various types of coverage, one of them being this, other coverages covering other types of risks that are faced by the carriers. Okay? So we now then, we would now then listen to the presentation, the lecture of Professor Alexander von Ziegler. Alexander von Ziegler is a professor of the University of Zürich in Switzerland. He is a partner in Schellenberg Wittmer's Dispute Resolution Group, a law firm in Zurich. He also has the firm's Trade and Transport Group and Insurance Practice. He was Secretary General of the International Maritime Committee, an organization that promotes the unification and harmonization of law and standards for the maritime industry around the world. He also was Secretary General of the International Union of Marine Insurers. He was also a delegate of Switzerland to various working groups at UNCITRAL, particularly the working group that developed the Rotterdam Rules, and he's currently delegate of Switzerland to the UNCITRAL working group that's currently considering a future regime for judicial sale of ships.
Hello and good afternoon. My name is Alexander von Ziegler. I'm here in Zurich, and unfortunately I'm not here live at the colloquium and the today's event, as I have a meeting when this film will be shown to you. But I very much hope that you have a wonderful and very interesting day. The subject that was given to me is fascinating. It is fascinating not just because the law is fascinating, but because the commercial background of the issues that I'm intending to cover are fascinating. And it shows that not only the sales contract is affected, but at the same time, principles of the contract of carriage and other contracts are actually interfering into the system in order to facilitate international trade. The Vienna Sales Convention, as the Rotterdam Rules, both conventions under the surveillance and the hospitality of UNCITRAL, they aim at facilitating international trade and commerce. And that is a very important aim, because it is an aim that will get rid of some obstacles that trade faces when they do daily trades. But at the same time, we have to be very modest, because we will see also in my speech that unfortunately not all obstacles can of course be solved by international instruments, but at least it gives a harmonized rail on which the trade can do its trade on a daily basis. I have started by emphasizing the importance of the International Sales Convention and the Rotterdam Rules, and I did so because I think we have to be clear that the contracts that the Vienna Sales Convention is looking after is the international contract. It's not the contract between international parties. I know that this will define the application of the Vienna Sales Convention, but more interestingly, it is the distance between where the goods initially are located and where they will have to go as a consequence of the sales contract. It is this very distance that gives all the problems. And the problem that we are looking at is, how is the seller comfortable enough to actually put his cargo on transport means and on the vessel, knowing that he will lose immediate control over the cargo and wait for payments. I mean, this is maybe one of the most important trade-offs that a trader expects when selling its cargo. I will now switch to my slides, and we'll come back live so that we can see each other again when I went through my slides. I also hope that you are having copies of my slides. If you want to check at the same time, you will see also an address where you can contact me should you have any questions. Unfortunately, since this is remotely taped and recorded, I cannot take questions, of course, and I could do that, of course, by emails or phones. Everything you should find in my presentation. So I will switch now to my presentation. All right, so we are having our slides, and I start with what I have just raised in the beginning, namely that the main issue that we are aiming at, and the convention has aimed at, is to find a solution for the seller, but also for the buyer, to be sure that the exchange of goods and monies are made in a way that is safe for both parties, so that the goods are not given to the buyer without any security and confidence that monies will be paid, but at the same time for the seller, that if money is paid, that he will receive the goods in good order and as the contract has described. So it is this kind of bilateral constellation that is the beginning of that problem. Let's dive into it for a while just to see how we can deal with that. In a normal contracts of sales, if I'm at a kiosk and buying a chocolate, usually I can see the chocolate and I can then exchange my money with the chocolate immediately. That gives confidence to the kiosk holder and myself that the trade will be safe. Now, the problem we really have is not the distance between seller and buyer, but actually the distance between the goods where they are and will have to be at the end of the transaction. We call that a sales contract for a distance and one for shipment, because the goods need to be shipped. So the contract of sale, the buyer will and the seller will have to decide on how to move the goods from A to B and how this distance can be overcome. And at the same time, the buyer will have to see how will he get those cargoes, and how will he be sure enough that he's buying the goods he wants and that the goods are corresponding to exactly the wish he has for the goods and for the price he wants to pay for. But the same applies for the seller, who of course wants the money as an exchange for the goods, and therefore wants to have some security that if he performs the contract, that this will be also honored by payment by the buyer. How can this be done? And how has this been done hundreds of years before we had a Vienna sales contract, sales convention, nor the Rotterdam Rules? What it was the system found by traders, not by academics or by any legislator. Actually, the traders found that it is the coexistence of the sales contract and the contract of carriage. Because when I ship the goods, it is the same, particularly under the CISG rule, but also under the Incoterms rule, CIF and free on board, so the C clauses and the F clauses, that the handing over of the cargoes under the contract of sale is practically the same as the handing over of the cargo to the carrier. So the same physical activity will actually be the starting point for the contract of carriage and will be the performance point in the contract of sale. So it is the coexistence of those two contracts which are mutually assisting themselves in the possibility of a later performance and security that we have found. The nice thing about the contract of carriage is that for the most part in the world, the contract of carriage will somehow give a right to the buyer to obtain the cargo at the end of the transport. So the contract of carriage will give different law to law and country by country some tools for the buyer to actually get the cargo at the end of transportation. Now, this is quite primitive and would not in itself be sufficient, I think, for the international trade. What was quite interesting is that the transport document, which is the main document in the contract of carriage, is showing a list of items as a matter of contract of carriage that are very helpful also for the contract of sale. So for the contract of carriage, this transport document will be the proof that a contract was made. The proof that a contract was made is also the proof under the sales contract that shipment was organized. The transport document is also a proof of delivery of the goods to the carrier. Again, that is at the same time the proof that delivery was made under the sales contract. The transport document is proof of quantity and quality for the purpose of the contract of carriage, but at the same time might give an indication to the buyer, looking at the document, that the goods were indeed transported in those quantities and qualities. And which is quite important as a matter of contract of carriage law, the transport document, if it is a negotiable transport document, is a key to the goods and therefore will be a key to the cargoes at destination. And I think here we start to have quite an interesting coexistence and interplay that we need to understand before we go into the issue of stoppage in transit and before we go into the rights of control under both sales law and the contract of carriage. The nice thing about this document is now a document that normally would only be a contract document between the shipper and the carrier is now suddenly becoming a document that is an important document for the contract of sale. As what is highlighted here, it is a proof of the performance of the seller that he has performed and delivered the cargo as under the contract, Article 31A and 35 CISG, also the quality and the delivery of the cargo. And the nice thing about the document is that it can be handed over to the buyer. The buyer can see the proof and can also, if it is the key, then get the key to get the cargo and the goods at destination. A quite important tool that we will look at later on. So the delivery of the goods at destination is the fulfillment of the performance of the while the sales contract is long fulfilled by the seller by handing over the cargo to the vessel in the shipment port. So we have the two moments. One is at the beginning of shipment, the performance of the seller is achieved by delivering to the vessel, and the contract of carriage is performed and delivered by the delivery of the goods at destination to the buyer. Now, I have told you that this, for hundreds of years, has been established by customs, by national law, and increasingly international convention have started to regulate this. And I will just have to look at those. The contract of sale is prominently regulated by the Vienna Sales Convention, which I named CISG here, and the contract of carriage is regulated by the Rotterdam Rules. And we will have a particular look to, of course, those two provisions. Let's start with the sales law and with the provision that are found in 71 of CISG, where you have the ability of any party to stop performance, to not perform if conditions are met and the conditions are established in 71.1 of CISG. But that's not exactly what we are particularly interested at the moment. This is just withholding performances because you're suspecting that the other party will breach the contract. What is particularly interesting is that we have a tool that even works after delivery of the goods. That means after the performance of one party. The seller already has performed by delivering the cargo and the goods to the carrier, but still has some right, and the right is called stoppage in transit. And that is a quite interesting provision that is prominently in CISG, and which is quite interesting. You see the full article 71 CISG here, where the first paragraph is the one that I have said before. We will need the provision later. Where we concentrate now is the second paragraph, and we look at it in more details. So the stoppage in transit gives the right to the seller that he can stop the goods in transit. We'll look at what that exactly means in a while. But the condition is that the seller has already dispatched the goods. So the condition of the right of stoppage in transit is that the seller already has performed under F clauses, C clauses, or the CISG 31A situation, namely by handing over the goods to the carrier. Now, he can stop that if he finds the grounds, and the grounds are described in paragraph 1 of 71, so we have to go back there and look at those in more details, and he has to find those grounds after the seller has dispatched the goods, because otherwise he will not have the rights. What is the right to stop? He can prevent the handing over of the goods to the buyer. Just be reminded, the handing over of the goods to the buyer will be eventually done by the carrier. The carrier will, at the end of transport, hand over the goods to the buyer as the consignee under the contract of carriage. And what the sales contract says is the seller may prevent the handing over of the goods to the buyer. And a very interesting point is not only in a normal situation, but even when the buyer already holds a document which entitles him to obtain them. You are reminded when I said that the bill of lading is the key to the cargo. So very typically that would be a bill of lading that the buyer would already have. He will not have had delivered the goods already at destination, but he has the documents in hand. And even then, stoppage in transit under the sales contract will operate. And an important sentence that is here, just for clarification more or less, it is quite logical. It, of course, only operates between seller and buyer. It is not an immediate right that you can enforce against anybody. It's just something that is working between the parties. And that now in more detail. So the seller has to already have dispatched the goods at the port of shipment. He will have performed his seller's obligation. He would hand it over to the carrier 31A CISG, and under Incoterms F and C clauses, he would have handed over the cargo to the carrier. So that's the first one. The goods are dispatched under a contract of carriage entered either by seller or by buyer. And under this contract of carriage, this means that the goods have been dispatched by the seller, and that is in the case of a C clause, or by the buyer in cases of the CISG 31 situation or the F clauses. So you see that the dispatcher or the contractual shipper will differ whether it is a C clause or whether it is a F clause. And that is, of course, later quite important when we look at the contract of carriage rights of control, as they might differ whether you are under a C clause or a F clause constellation. Then the second point is that the dispatch and delivery need to be done before the grounds described in the preceding paragraph become evident. Those grounds we will look at more just in a second, in more detail, are practically the loss of confidence in the fact that the buyer would be able to and willing to pay the price. We'll come there in a second, namely here. You see that in 71 CISG it is said that it becomes apparent that the other party will not perform a substantial part of his obligation. Of course, the payment is one. As a result of serious deficiency in the ability to perform on or in his creditworthiness. So as soon as you have proof of that, you are in a possibility to actually call upon your right to stop in transit. Only, of course, you need to know those facts after you have dispatched, because when you have dispatched, you have practically forfeited those rights. The only right you have forfeited is the stoppage in transit. Any other right, of course, will be still applicable. What can you do? You can prevent the handing over of the goods to the buyer. And this means that the goods still need to be in transit. The moment the carrier has handed over the goods to the buyer, the right to stop in transit will disappear. And it's only a right against the seller. And it's only a right as a matter of sales law. So you need tools. The only thing it says is if you are avoiding and preventing handing over, you're not in a breach. Even if you have performed, but if you are under the conditions and you met the conditions and prerequisites of 72 and 1, you are able to stop the cargo and you have not violated any of your sales contract. That is what the sales law is saying. And what you can do as this is the contractual right in the contract of sale, you can stop the handing over to the buyer. And you can do that, we already touched this, even if the buyer already has a document that would entitle him to obtain them. And so whether or not you have a document that entitles him or the buyer to obtain them is, of course, a matter of the transport law and the contract of carriage. And we will have to go into that because it is really quite important that you see the differences of the different transport documents. The interplay between the sales law, stoppage in transit, and the right of control are quite different depending on which document is chosen by the parties in the contract of sales, because very often in the contract of sales it is specified what document is needed in order to perform the contract. If it is not, then the seller is free, or the party is free that is organizing the transport to actually choose the applicable transport document. We have seen that the document the bill of lading is a document of title and a key to the goods, and therefore the moment this document is given to the buyer is able to ask for delivery of the goods, can enforce that against the carrier, but what the sales law says is that even then the shipper may prevent it with whatever tools is available to him. The tools are not regulated by the sales contract, but need to be found in other legal relationship that can be found. So that is where the buyer intends to get the cargo on the basis of its bill of lading, but of course the stoppage in transit would not allow that and somehow stop it. What is needed, I just mentioned that here, is that a notice is given from the seller to the buyer, and everything else is regulated in CISG, and gives a certain fairness to the buyer, can give security, etc. So that's quite an interesting thing, which I will not go into. It just shows that the Vienna Sales Convention, again, is very pro-trade and pro-contract. So it can be rescued, but of course, now the buyer is in the duty to rescue it by submitting sufficient security so that the contract can be performed. Let's move now into the contract of carriage. And actually, this is a move from Vienna to Rotterdam, because another convention that UNCITRAL has more recently created are the Rotterdam Rules. And it is quite unique the way the Rotterdam Rules were written, because it was really meant to be not a convention on the contract of carriage only, but actually one that is complementing trade contracts such as the sales contract, but also letters of credit and other contracts that are usually combined in one trade lane and therefore need to be all coexisting and able to work with each other. How is this now? What is the answer of the contract of carriage to the stoppage in transit situation? We had this situation where you have the red arrow showing that the seller is able and has the right to stop the handing over to the buyer. Now, how can this be translated into the contract of carriage? And the answer is through the transport documents and through, depending on the documents, on the right of control that is given to the parties in the contract of carriage to actually stop the delivery, so that the carrier is bound not to deliver at destination. And that's the tool is called the right of control. The chapter on the right of control in the Rotterdam Rules is quite elaborate, and we are not here to go from one to the other in all details, but it is actually a right of one party. It's called the controlling party here in the Rotterdam Rules, to modify the instruction, to have the right to obtain delivery of the goods and change the delivery place, etc. So it's a quite wide range of rights that is given to the party under the right of control. And with this right of control, we can prohibit the delivery of the goods, but at the same time, once the goods are delivered, the time for such a right of control has elapsed, and of course then we are not anymore in the contract of carriage, because the contract of carriage has been performed. I said already that it is quite important that we make differentiation between the different transport documents, and the Rotterdam Rules have been very careful to do that. There are a huge variety of transport documents in the market, but the Rotterdam Rules have really decided to stick to the main characteristics so that the party can stick under one of them. One is the Seaway bill. This is maybe the less strengthened document. It's the most flexible document. And it is nevertheless an evidence of quality and quantity of the goods. It's evidence of the contract of carriage. And most importantly, it's the evidence of delivery to the cargo. So translated into the sales contract, it is also an evidence of the delivery of the goods under the sales contract at the port of shipment, and can give some indications on quality and quality and quantity. Of course, the evidence has to be established from case to case, but it gives some comfort to the buyer that if that is all true, the cargo have been delivered as has been stated in the contract. Then we have another document, which is a hybrid document. We call it straight bill of lading. It is a Seaway bill, if you may say so. So it has the same kind of characteristics, but at the same time, it has become by contract and by notation a key to the cargo at destination. It is not negotiable, so you cannot not trade it to another party, but at least it is the key. So we have already a much stronger document with a straight bill of lading. Some trades love that document. It is nevertheless quite rare in trade. So the Seaway bill and the bill of lading are the most current documents. So the next one, the bill of lading, is actually a negotiable transport document, and as the name says, it is the same as a straight bill of lading. It's the key to the cargo. We have all the characteristics that we had before also under the Seaway bill, plus it is negotiable. So it can be transferred from a party to a third party, to a fourth party, a fifth party. And of course, that is the tool then when we look into string contracts, commodity trades, etc. So we are actually trading, if you want, the document. We can really trade the bill of lading instead of the goods or replacing the goods. And then we have the electronic equivalent of the bill of lading that has the same prerequisites as all the other documents. So just to remind what I said is that all of those functions are not inventions that are made for the contract of carriage. While they are ruled in the contract of carriage and while they are ruled in the Rotterdam Rules, the purpose is to facilitate the sales contract. That's the only purpose that they have all those different tools and variants. So if you want, the Rotterdam Rules are serving the purposes of the sales contract, to the extent, of course, possible. Here we have the standard. The beginning is the Seaway bill. In the Seaway bill, it is that the C-class seller, and only the C-class seller, has a right of control under the Rotterdam Rules in the context of the stoppage in transit, because it is called the shipper is the controlling party, and that is the contracting shipper. And the contracting shipper in sales environment can only be the C-class seller, because only the C-class seller has the duty to organize and contract a transportation contract. So this already gives a certain limit. At the same time, you have to know that those rules can be changed by the parties, and therefore with changes in the document and with some amendments, it can also work as a document that can work and transfer the right of control to other parties, like the documented shipper. That means the shipper that is decided contractually to be the party to have the right of control. So we can change that, but it needs a change that needs to be done if we want to use that and the right of control in the context of F clauses. Now, we don't need that change if we go into the straight bill of lading. Why? Because we have a key. So we actually, as long as we have the key, and the we can be a documented shipper, this can be the seller that is not contracting for the contract of carriage, but actually imposes himself to be named as the shipper in the bill of lading, and will remain being the party having the key, and therefore will have the right of control. If the full set of documents is provided to the carrier, the instructions can come from that party. So that's quite an effective tool now to intervene if you are in a situation of a stoppage in transit where you want to stop the cargoes to be delivered at the end of the transportation. And even better now with the bill of lading, here we really are having a tool that can be transferred, and therefore the right of control can be held by any party that is holding the full set of documents at the time. And we'll see that is hugely important for a situation that I will call letter of credit situation that we will look at in more details. And I think we don't need to mention a lot apart from the fact that, of course, the same thing applies in the electronic environment. This sounds all very enthusiastic, but we have to be quite modest here because, of course, the carrier cannot be forced to do anything. The instructions given to the carrier need to be reasonable, and you cannot interfere with normal operations. In particular, if you are in the container trade, you cannot deviate the whole container vessel just because you have a problem with your single buyer. So therefore, yes, it is a right, but there are some limits, and of course it has some costs, and the costs need to be reimbursed, so it has a price tag. The price tag comes from the contract of carriage. Of course, the carrier is not a slave of the situation and doesn't have just to obey to all orders by a party or to the sales contract. Of course, the carrier will ask some money or at least security for the additional expenses. Those, I think, are important caveats that we need to put into the equation because if you want to value this in a commercial sense, you need to know that if you go that path, it might cause you to pay more costs. But looking at the prices that are outstanding for the goods sold, it might be a good investment. Now, we only have looked at the maritime plus environment in which the Rotterdam Rules were written. Of course, we have to acknowledge that a lot of transportation is made outside of the maritime container plus business, but it's air transport, or road transport, or rail transport. And it's interesting to see that the same kind of right of control is in all of the conventions that regulate those modes of transport. Just a caveat here, we can't go in all the details. They are different from convention to convention. So you need really to observe each of the applicable instrument for your case, as they are not fully aligned. And the lack of alignment is not so much a careless drafting or by the drafters of those conventions. It's that those trades are just different. They operate different, and I think it was a right concept to actually translate the actual environment, technical environment and customs into the convention rather than just to give a authoritative interfering solution by a convention that is not the situation in the particular trade. Now, I have listed a number of special issues that we might want to look at. One is the letter of credit, and you see some other points that I will list one after the other. Do we really need a stoppage in transit in the context of letter of credit? You see that here a particular situation where the bill of lading, instead of being sent directly from the sender to the buyer, will be handed to the bank against the money. So that means the seller should not be in a position to have any question on the solvability and the creditworthiness of the buyer. It is solved by the letter of credit. So my answer is, normally, stoppage in transit, you should not be worried in a letter of credit situation. Normally, because there are many cases where, particularly if something is wrong with the buyer, the banks become very picky and might be very, very much looking into all the deficiency of the documents and find any excuse to refuse payment under the letter of credit because of lack of conformity of the documents. And then instantly your stoppage in transit right becomes crucial. The other thing I want to say is that, of course, the right of control is the tool that is allowing the letter of credit to operate. Because namely here, the bank is able to control the goods through the right of control and has some security that the goods are not handed over to the buyer without a payment made from the buyer to Bank A. So, what about string sales? String sales really are sales, commodity trails where the same goods are sold on from one buyer to the next. So a buyer becomes a seller and the buyer becomes a seller, etc. So what is different and what is quite interesting is that we have in this example here which is quite simplified. We have 1, 2, 3, 4, 5 contracts. Maybe some are under the auspices of the Vienna Sales Convention, others might not be. You have maybe some rights of stoppage in transit, but maybe only one of the buyers has a finance problem. So how does that all work? How is the chain reacting to if one party, one seller has a right against one buyer of stoppage? You would actually stop the entire chain, and I think huge and very interesting legal questions could arise. Why do they not arise? Again, because normally those trades are made under letter of credit. That means that those stoppage in transit situations need not to be done. Why is the right of control not an issue? Because you have only one contract of carriage. While you have 1, 2, 3, 4, 5 contract of sale, you only need one contract of carriage. So you only have one right of control, which is transferred with a bill of lading from one party to the other. So the contract of carriage can manage very well a string contract, and I would say the sales contract can do, because of course you can operate through letters of credit, which normally will be done by customs. So another issue that we have looked at. Now, one way to enforce your right was the right to of control, but of course it is only operational in certain circumstances, as we have seen, and will stop with the right of control will stop with the handing over of the bill of lading to the buyer, because then normally the seller has lost control over the right of control. And therefore you need other tools. You can still operate your right to stop the cargo in transit, but you need other means. And what is normally done is that you try to find an injunction. The competent court, which is the competent court? Is it the court where the cargo is positioned at the time of your injunction? Is it the competent court in your sales contract? Quite interesting issues that you have to deal with, in particular also if the competent court in your sales contract is an arbitration. So I just open the topics. I can't give answers to all of those situations, as particularly they are most likely regulated not by one particular law, but actually by many national laws. Also, it might be coinciding with bankruptcy proceedings that have certain hunger for cargoes that are being shipped to the defunct and bankrupt buyer, and therefore you might want to see how you can enforce that in those proceedings. Most likely you want to be able to get those cargoes out of the bankruptcy insolvency mass and being handed over those cargoes to you. And yes, then the last point we already mentioned. An issue that is the last one that I want to mention, apart from the last slide that I will show just now, is academically we were quite interested, because we would like to be able to answer questions also of the right of possession and ownership. The only issue I have to mention here, neither the Vienna Sales Convention, nor the Rotterdam Rules, neither the contract of sale, nor the contract of carriage are actually affecting directly or ruling directly on possession and ownership. Of course, the institutions and instruments that we have looked at might, under the applicable law on possession and ownership, in rem rights, etc., have an effect, and I'm sure it does, and certainly also in my law, the Swiss law, it would. But we do not find the answer in those instruments, but rather, of course, in the applicable law, in the applicable courts on those very difficult questions that we are very glad that we do need to answer today. The last point I want to make, is there a freedom of contract? And the answer is yes. It is not so much a surprise to you if you're looking from the angle of the Vienna Sales Convention, because of course the Vienna Sales Convention is non-mandatory, and therefore will give you a lot of room to actually find solutions that are tailored to the situation. But the surprise really is in the contract of carriage, because the people who deal with the contract of carriage in international conventions would know that most of them are largely and heavily mandatory, and therefore you are surprised to see that the Rotterdam Rules, rightly so, and we had to defend that in the coming of the Rotterdam Rules, are non-mandatory in that respect and can be changed by the parties in relation to the carrier. Of course, this is now a relationship you have to deal with between the party buying the transport and the carrier. And you have examples, and the Maersk Line example is a good one, because it shows that, of course, the carrier might give you an indication, yes, you can give a right of control, you can stop the cargoes under your sales contract with me, but those are the rules and those are the limits. And Maersk, as a big container line, will not be very happy to stop the ship with the many thousands containers on board just because you have a problem with your buyer. And therefore, I think, and that's quite a good ending, I think that while we have conventions that give the rail, there are so many ways that you can influence as a trader, as a lawyer, as a bank, as a party in that situation, how those rights can play out and whether they should play out in your situation. And therefore, I think it is a good example of how, particularly the Vienna Sales Convention, has given the tools to the parties and the freedom to the parties to actually tailor the transaction to its liking. Yeah, and with this last slide, I want to thank you very much for attending this seminar and being so attentive to what I have explained to you. As I said, should you have any questions, please do really not hesitate to contact me, and I will be very glad to assist you in finding answers to your questions. I wish you a very, very good day, and hope to see you someday. Bye.
So it's 10 to 5 now. I'd suggest that, I don't know whether you have questions or you prefer to write questions that then have them addressed straight to Professor von Ziegler. We'll be posting his video also in the on Moodle so that you can also then listen to it again. It's a lot of content in a rather complex area of the law, and one that he addresses in particular because there is not a written answer to this, which I think should have become obvious from his lecture in any of the conventions. Actually, those domestic laws would not give a written answer to that. But bear in mind that none of the international conventions also addresses this particular function, for instance, of the bill of lading, in terms of the possessory function, up to the Rotterdam Rules. The existing conventions, both the Hague Rules, the Hamburg Rules, all of them deal with the content of the bill of lading, but none of them deals with the effects of the bill of lading as regards possession and property of the goods. This is something that is addressed in some national laws, but at the international level is the result of custom and a practical evolution of the law merchant. We'll now be looking at the liability regime for the carrier under the various modes of transportation, but looking primarily at ocean transportation, and looking then also incidentally at the other means of transportation to compare it to ocean transportation, ocean carriage. And there are three elements here that we'll be focusing on. One is the basis for liability. For what incidents the carrier is liable, under what circumstances, under which grounds the carrier can be relieved of liability, and who bears the burden of proof. The second element are the limits of liability and exemptions of liability. And the third is how to deal with liability issues in multimodal carriage. As regards the period of liability, under the regime of the Hague Rules, the carrier is liable from the loading to unloading. Under the Hamburg Rules, the carrier is liable for damage that happens to the goods during the entire period in which the carrier is in the custody of the goods. And under the Rotterdam Rules, Article 12 says the carrier's liability begins when the carrier receives the goods for carriage and ends when the goods are delivered. What is the practical difference between these three regimes? Is that and the Rotterdam Rules and the Hamburg Rules are only slightly different because the concept they mean is essentially the same. That is, from the moment that the shipper brings the goods to the carrier is liable for everything that happens. That includes necessarily damage that happens, that occurs to the goods during the operations of loading and unloading, loading on the ship at the port of origin and unloading from the ship at the port of destination. The Hague Rules still apply only from loading to unloading, loading meaning the moment that the goods have passed the ship's rail to be placed on the ship's desk. That is, if damage happens to the goods while they are by the ship, but not yet on the ship, right? The carrier is not liable. That's why this rule is also known as tackle to tackle. So that's the moment that the tackle lifts the goods up the ship's rail and then the goods cross the ship's rail at destination. Makes a significant difference for the shipper because that happens to be a crucial moment in the operation where most damage occurs. And if the damage occurs before the passing of the ship's rail, the carrier is not liable, or that liability, or to be more precise, that liability is not covered by the Hague Rules, which means that the carrier can exclude that liability in the bill of lading, saying the carrier is not liable for damage that occurs during loading, right? So a significant difference. What kind of cargo do they cover? The Hague Rules defines the contract of carriage as a carriage that, or a transportation of cargo on deck, so in the vaults of the ship. So cargo that is loaded on dock, not on deck, right? And expressly excludes carriage of living animals. Again, the practical import of this situation is that the carrier under the Hague Rules is able to disclaim liability for damage to living animals and also for damage to goods that are declared to be carried on deck. Right? Both the Hamburg and the Rotterdam Rules cover both situations. So the liability regime is mandatory and applies also in both situations. The period of the responsibility under the other conventions, the unimodal conventions, be they Montreal or CMR and OTIF, are also more similar to those under the Hamburg and the Rotterdam Rules. Montreal expressly refers to the period in which the goods are, the carrier is in charge of the goods. So it extends to any period before unloading and after unloading. The same principle is also applied under CMR and COTIF. So you see that generally the land and air and the more recent maritime conventions are more favorable to the shipper in this respect, and the old maritime regime is more favorable to the sea carrier. As for carriages covered In air carriage, obviously, you don't have the notion of deck carriage because you cannot carry things on the top of an airplane. That's obvious. The second thing is that Warsaw Convention does not contain provisions on livestock, reason being that normally animals are not transported in en masse in airplanes. People may carry their pet dogs or cats on their plane with them, but not as a merchandise, not as import-export goods. The CMR and COTIF conventions do cover livestock, but both of them typically exclude the carrier's liability for livestock, because in both cases it is considered that these are delicate articles of transportation and the carrier should not be liable. And they do cover also transportation on open or unsheeted vehicles, but again would exclude the carrier's liability under those situations. Now, how is the liability regime structured? And if you remember the summary I provided of the Harter Act and the way that was incorporated in the Hague Rules, this would sound familiar to you, that basically you have a system of specified duties that would apply to the carrier, and the breach of those duties would engage the carrier's liability. The liability would be a presumed liability by the fact that the goods arrived at destination damaged or they're missing. And there are exemptions provided by statute to that liability. And the carrier that complies with the duties applicable to the carrier is able to benefit from a limitation of liability, including a monetary ceiling. This system is a rather elaborate system under the Hague Rules, which provides for a certain number of duties that the carrier must undertake before the voyage to comply with the carrier's obligations under the warranty of seaworthiness. Then a set list of exonerations that benefit the carrier, and there's one catch-all exemption which you'll see in a moment. The Hague Rules provide no liability for delay in delivery of goods. And there's also, under the Hague Rules, no explicit rule on the burden of proof. And this has been one of the biggest causes of litigation in maritime law, the fact that it's unclear who has to prove what to when the liability of the carrier is in dispute. Now let's look at this more closely and look at the specific language under the Hague Rules. Article 3 of the Hague Rules says, the carrier shall be bound, and here pay attention to the formulation because every word counts. At the beginning of the voyage, to exercise due diligence, to A, make the ship seaworthy, B, properly man, equip, and supply the ship, C, make the holds, refrigeration, and cool chambers and all other parts of the ship fit and safe for the reception, carriage, and preservation of the goods. Second set of obligations, the carrier shall properly and carefully load, handle, stow, carry, keep, care for, and discharge the goods carried. So these are the typical obligations of the carriage, okay? Now, what do you think that the expression before the voyage means? It means, and it is interpreted by courts literally, that the carrier has to prove that it took the necessary steps to provide a seaworthy ship before the voyage. If the ship ceases being seaworthy during the voyage, that is not necessarily a breach of the carrier's duties. And that's also I said, here we have to look at every word in this formulation because each word counts. And the carrier has to, Article 3.1 doesn't say the carrier shall before the voyage make this ship seaworthy, shall exercise due diligence to make the ship seaworthy. This is what, under French law, the legal theory, you call an obligation of means and not an obligation of result. It's a best efforts obligation. So if the carrier proves that I've done all that I think I should do before the voyage to make the ship seaworthy, but the ship was in fact not seaworthy, the carrier has still complied with its obligation. It's not a firm, strict obligation. These are fundamental obligations under the Hague Rules, meaning these things the carrier cannot exclude by contract. The carrier cannot say, I will not provide a seaworthy ship. The carrier shall not say, I will not carefully load and stow the goods. These are basic obligations, and any clause pretending to exclude that obligation will be null and void also under the Hague Rules. Hamburg Rules uses a different notion. At the time the Hamburg Rules were negotiated in the 70s, there had been enough complaint about the fact that the obligations under the Hague Rules were not firm, they were only due diligence, they only applied before the voyage, and that this system of liability was too complex and complicated and favored the carrier. So the Hamburg Rules attempted to provide a completely different basis of liability and on the principle of presumed fault by the carrier. So if the event that caused the damage to the goods happened during the carriage or during the period in which the goods were in the custody of the carrier is presumed liable unless the carrier proves the absence of fault because the damage was attributable to an event of the type of a force majeure or an event attributable to a third party. And then it has special rules on fire and salvage. So the carrier is liable for loss or damage resulting as well as from delay in delivery if it occurs during the period in which the goods were in charge, the carrier was in charge of the goods. The carrier also, there's also express provision for liability for delay in delivery of the goods under the same circumstances. But as I mentioned to you, the Hamburg Rules are only being ratified by 34 countries. And in an attempt to provide some uniformity when the Rotterdam Rules are negotiated, the majority countries in the world were those that still had the Hague Rules. And the argument was, we need to preserve a system that is similar to ours rather than adopt the minority system as the prevailing rule. So the philosophy negotiating the Rotterdam Rules was to try to bridge a compromise and correct the most obvious deficiencies of the Hague Rules into a more modern regime, but preserving language and structure as much as possible. So the Hamburg Rules still link the liability of the Rotterdam Rules, still link the liability of the carrier to a breach of duties of due diligence. However, it extends this duty of due diligence also to the entire voyage and not only before the voyage. So it means that the carrier must exercise due diligence to provide a seaworthy ship at the beginning of the voyage, and continue exercising due diligence to ensure that that ship remains seaworthy throughout the voyage until the arrival of the ship at the port of destination. Then there are specific grounds of exoneration, but there is not a so-called catch-all exemption as exists under the Hague Rules, where it is still possible for the carrier to exclude liability in addition to what is already expressly provided for there. Liability also for delay is contemplated in the Rotterdam Rules, and there are explicit rules on the burden of proof. So this is contained in Article 13 of the, and 14 and 17 of the Rotterdam Rules. And what is interesting also about the current formulation of the Rotterdam Rules is not only the rules as such, because as we know that they have not yet entered into force, but not only they are interesting because they represent a compromise between the old Hague and the Hamburg regimes, but also they codify in that manner the case law in the application of the Hague Rules, which has evolved towards providing a greater protection to the cargo owner, also in the structure of the provisions and burden of proof under the Rotterdam Rules. So there is an obligation to exercise due care to properly handle and stow the goods, and exercise due care in providing seaworthy ship, properly crew and make the ship fit to carry the goods at the beginning of and during the voyage. But it creates also a presumption of fault. If damage happens to the goods during the voyage, the carrier is liable if the claimant proves that the cause of the damage happens during the period in which the goods were in the possession of the carrier. So from the moment in which you deliver the goods to the carrier until the moment the goods have been discharged by the carriers. This was not clear under the Hague Rules, that there was a presumption of fault of the carrier. And under the Hague Rules, some courts require the claimant in a cargo claim to first prove the carrier's fault. And the Rotterdam Rules now, more like the Hamburg, they reverse the situation, say there is a presumption of the carrier's liability, and the carrier can rebut that presumption under Article 17.2, if they prove that the cause of, or one of the causes of the loss or damage are not attributable to his fault, then, and or it's the consequence of one of the acts that exclude the liability of the carrier, and we see in a moment what they are. You see, then you basically we were talking about the situation where either the cargo owner has to prove the fault of the carrier, that's the old Hague system, and the more modern regimes you have a reversion of the burden of proof, a presumption of liability of the carrier if the damage occurs during the period in which the carrier was in charge of the goods. You have essentially the same system as in the current Rotterdam Rules and the Hamburg Rules for carriage by air, road, and rail. There is a presumption of liability of the carrier if, and all the cargo interests need to prove is only that the damage occurred at that point in time. And then it's up for the carrier to invoke any reason that would exclude the carrier's liability under those circumstances. You heard the expression a catch-all clause. And this is a curious provision in Article 4 of the Hague Rules that says, neither the carrier nor the ship shall be liable for loss or damage arising or resulting from unseaworthiness caused by the want of due diligence on the part of the carrier, and comes the whole list of obligations. Whenever the loss or damage has resulted from unseaworthiness, the burden of proof in the exercise of diligence shall be on the carrier and other person claiming exemption under this article. So what does this mean? It means that the carrier has a duty of due diligence, right? But that duty of due diligence is offset by the possibility of the carrier to demonstrate that it has exercised the duty of due diligence as mandated by the convention. So even though the ship was seaworthy, if the carrier can demonstrate I did what I needed to do to provide a seaworthy ship, I can escape the liability under the Hague Rules, under Article 4 of the Hague Rules. Now, the exclusion of liability. And this is another point where there's a big difference between the two systems. As I mentioned before, the law on carriage of goods by sea developed from the practice of carriers and ended up in a compilation of standard terms that found its way into the Hague Rules and became an international convention. And you here have this long list of exceptions and say neither the carrier nor the ship shall be responsible for loss or damage arising out or resulting from. And the first thing is act, neglect, or default of the master, mariner, pilot, or the servants of the carrier in the navigation or in the management of the ship. Now, how does that relate to general contract law? Under most circumstances under contract law, in an equivalent situation, this will correspond to a truck owner saying, I take your goods for carriage, but if the driver causes an accident during the ride, I'm not responsible, I'm not liable, I'm not paying for your goods. Or it would mean that in a law firm, the law firm owner would say, I would handle your case, but if one of my legal assistants misses the deadline for filing an application or you lose it, I'm not liable. In most areas of the law, this kind of waiver of liability would not be enforceable. It would be unconscionable, would be against public policy, and it would be considered to be an unfair clause. It is still the law in all countries that have ratified the Hague-Visby rule. And I mentioned the history of maritime law because the history allows us to understand some of these things that look like an anomaly to us in the law. The reason being, the origins of maritime law and the origins of these exclusions is way back in time when carriage of goods by sea was described as a common adventure. In old Admiralty books, we still find that language. Meaning, there was a ship owner who contributed to the adventure with the ship. There was a cargo owner who put his cargo at risk for that carriage. And then there was a captain and a crew who were unrelated to the ship owner and who came and joined for that particular carriage. And the moment that ship sailed, the ship owner had no contact to them and no means of controlling what is happening at high sea. So the ship owners were also risking their own ship in that, in the hands of a captain who was not necessarily their employee and with whom they had no contact because there was no radio in those days, there was no telegraph, there was no internet, no means of communication. And if the ship would catch fire on the sea, or if the ship would be assaulted by pirates, or if the ship would sink because the captain interpreted badly the stars and they could not operate the navigation mechanism, the owner of the ship would say, I cannot be liable for that because I had no control of what was happening in high sea. And that became standard to exclude liability for what we call fault in navigation or nautical fault. That's the term that describes this exclusion of liability. And it's still the law under the Hague Rules. Fire. And the reason being the same. Again, the ship owner would say, I have no means of controlling fire on the ship at the high sea. And if the cargo is damaged by fire on the high sea, I cannot be held liable and for that. And that was a standard exclusion, found its way also in the Hague-Visby rules. Then the third one, perils, dangers, and accidents of the sea or other navigable waters. The explanation that provided that time was also exactly the same. The sea is a dangerous thing. The ships were not particularly heavy. The technology was not particularly developed. And they will be also actually rather fragile when facing a hurricane or facing a tsunami or another of these significant accidents of the sea, or a very strong winds, and the ship would then sink. It was considered to be a risk that was too high for the ship owner to accept. And the ship owners excluded that risk routinely. And then continues the list. Acts of God means anything, maybe a blizzard, maybe another accident of that nature, a volcano eruption or something similar. Acts of war, you're being attacked by the enemy in the high sea. Act of public enemies, these are lovely old-fashioned formulations. This means pirates and other type of mischief makers that may cross their way on the sea. Arrest of restraint of princes, rulers, or people. It's the famous fait du prince exception on the French law. It means if you have a foreign authority that arrests your ship and you're not allowed to sail onward, and then your perishable cargo is lost. Again, the owner would say, I cannot be held liable for that. Quarantine restrictions is a familiar subject to us in COVID days. Acts and omissions of the shipper or owner of the goods, and here we're all getting into areas which are more familiar also to other areas of the law. Typically, the carrier, no one would assume the consequence of a breach by the other party. Strikes, lockouts, or stoppages, riots and civil commotions, saving or attempting to save life or property at sea. When we heard about soft law developed around the world by industry to set standards, we heard reference to gross average, general average. And this is an example. What happens is you are, say, after a storm, the ship is unstable, or there's water entering the vaults of the ship. So the ship has to dispose of the weight, otherwise it will go down. And then the captain gives the order to the crew, throw out half of the cargo. to save the ship, to save lives, or save the rest of the cargo. Or if the ship has to make a sudden maneuver to reach another ship that is sinking, that send an SOS message. And in that maneuver, in order to save life, you have then to throw out part of your cargo from the deck of the ship. Again, there's a situation where liability will be excluded, and there are rules for sharing that loss. Wastage in bulk or weight or any other loss or damage arising from inherent defect or quality or vice of the goods. We know that certain goods, there is a natural loss in weight during voyage. Some may increase in weight through humidity, some may be lost in voyage through humidity, some may be lost simply as a natural loss in the process of loading or unloading. Again, these are natural losses that are not considered to be cause of liability of the carrier. Insufficiency of packing, this is an obvious fault of the shipper. If the shipper does not pack the goods in a manner that would ensure that they arrive at the port of destination in good condition, the carrier is not liable. Latent defects not discovered by due diligence. All this, the later ones, are more familiar causes of exclusion of liability also for other contractual obligations. And then if this list was not long enough, we have a Q, last paragraph Q that says any other cause arising without the actual fault or privity of the carrier or without the fault or neglect of any agent of the carrier. So just to make sure that the carrier is only liable for its own fault and sometimes not even for its own fault. And if the list is not enough, we then also have this last possibility of exclusion of liability. Not surprisingly, this long list of exemptions was a cause of significant criticism by cargo owners. They're very unhappy with the system. And one of the main attempts in negotiating with the Hamburg Rules was to render the entire regime fairer for the cargo owners and reduce the exclusions of liability. The Hamburg Rules do that through a more radical surgery, so to say, in the system of the Hague Rules, by basically referring back to the notion of absence of fault. So the carrier is presumed liable for anything that happens during the period in which the carrier was in charge of the goods, unless the cause of damage is an event that is not attributable to the fault of the carrier, or was caused by fire, or unless the plaintiff proves that the fire was actually caused by the fault of the carrier itself, or specific risks related to the transport of animals, or measures taken to save life at sea. So you see, it's a radical surgery, and it's all in one single provision under the Hamburg Rules. We don't have this long list. It's simply say the carrier is not liable if the carrier proves that the cause of the damage was any event outside the carrier's fault. By doing that, the Hamburg Rules implicitly removed the fault of navigation and removed the exclusion under the perils of the sea, because that is supposed to be mastered by the carrier during a voyage. This was an issue very highly debated at the time the Rotterdam Rules were negotiated. And we had then two clashing positions. One was the one advocated by those countries that had ratified the Hamburg Rules, those 34 countries, saying we like the Hamburg Rules system. It's simpler, it's easy to understand. We don't have this complex list. And all we have is a presumption of responsibility and one possibility of exoneration with three specific exemptions. But the other group, which actually represents the majority of the countries in the world, carried the day and said, no, we prefer to stick to the structure of the Hague Rules, but improve it. So we still have the system, these obligations to do before and during the voyage, the breach of which would entail the liability of the carrier, and a long list of exemptions, right? So the carrier is exempted from liability if, alternatively to providing, as it would have been able to provide under the Hamburg Rules, proof that the damage was not caused by its fault, if the carrier is able to prove that the actual cause of the damage was, and here see we begin already by act of God. And that means the Rotterdam Rules abandon the exclusion of liability for nautical fault, for the fault of the master, the captain of the ship. This was very heavily debated at that point in time, and imagine still in the year 2000, up to the year 2008, when the Rotterdam Rules were adopted, we had people advocating to maintain the exclusion of liability for nautical fault. But at that point in time, most people recognize this day and age is very hard for a carrier to say, I had no means of knowing what was happening on the ship during the voyage. And that exclusion was no longer justified. And that exclusion was so radically inconsistent with the liability patterns in other areas of transportation, but also in other areas of the law, that it had to go, and eventually it went. Also, the treatment of the burden of proof in the Rotterdam Rules makes it clear who has to demonstrate what. And even though it kept most of the list contained in the Hague Rules with very similar language. For instance, there was also a very heavy debate about should we still talk about acts of God in the year 2008, or couldn't we use a more modern phraseology? The argument for keeping that was simply that there are about more than 70 years of case law interpreting the meaning of act of God under the Hague Rules. And that body of precedent would have been lost by adopting a more continental European phraseology as we use in the Hamburg Rules. So we have essentially the same list of liabilities, but what the Rotterdam Rules do, as I said, they clarify the burden of proof by simply saying the structure of these articles in this way. The carrier is presumed liable. The carrier then can say, try to exclude liability by proving the cause of the damage was not its fault, or the damage was caused by one of the events that exclude the liability of the carrier, one of the exonerating events. But then the claimant can still prove that, yes, it was one of those, but coming to a question that was asked before, the carrier contributed to that damage with its own negligence, right? Or that the actual cause of the damage is the breach by the carrier of the duty to provide a seaworthy ship at the beginning or during the voyage. For example, if the goods are lost because water leaks in the vaults of the ship, right? The carrier then argues The actual cause was a peril of the sea, because as the sea was crossing the Strait of Malabar, there was a very heavy storm, and heavy rain and rainwater and even seawater got into the ship, and this was due to a peril of the sea. So the carrier should not be liable for the loss. But if the cargo owner can prove, yes, it is true that there was that storm at that point in time, but the conditions of the fault of the ship allowed the damage because the doors were not properly sealed, either at that point in time or because they were defective at the beginning of the voyage, so that there is a contributory negligence of the carrier and one that amounts to a breach of one of those basic duties. And if that is the case, the carrier will still be liable, even though the carrier can prove that the cause of the damage was one of those exempting events. These, so to speak, ping-pong way of dealing with liability, the cargo claim proves the damage, the carrier invokes the exemption, the cargo side proves that it was for the lack of the due diligence of the carrier, then the carrier is held liable. This was not clear under the Hague Rules. And under the Hague Rules, it was then very often the carrier would simply invoke a peril of the sea or an act of God, and that by itself would be the end of the story. And in many countries were not clear that the cargo owners would have the possibility of still holding the carrier liable and accountable. How is this dealt with under the other conventions? And the other conventions are very similar to what became the Hamburg Rules in the formulation, because not all of them have a long list of exemptions, but under the Warsaw Convention, the carrier is not liable if he proves that it took all measures necessary to avoid the damage, or that, but in the Warsaw Convention, you also had originally the same exclusion of liability for nautical fault. You see, it's called here negligent pilotage of the aircraft. The reason in 1929 was similar to the reason for the Hague Rules in 1924. This has changed in the Montreal Convention, and the Montreal Convention Article 20 refers to the carrier's ability to prove that the damage was caused or contributed by the negligence or the wrongful act or omission of the person claiming compensation or other events outside the carrier's control. In the case of carriage by road, we have, as we saw, the same principle of presumption of liability of the carrier if the damage occurs during the period in which the carrier is in charge of the goods, with a list, a much shorter list of exemptions. And they are, apart from the carriage of goods in an open wagon, all of them related to either the fault of the shipper, for instance, in handling, loading, and storing the goods, or defectively packing the goods, or they are related to acts outside the control of the carrier, or also, as I mentioned before, the carriage of livestock. Same thing under the OTIF Convention for the carriage by rail, a very similar notion of exclusion of liability under the limited circumstances, no nautical fault, no acts that could possibly be attributable to the carrier itself, typically acts of a force majeure or attributable to the shipper. Now, let's get to the monetary limitation of liability to complete this panorama. So one thing is the limitation of liability in terms of exclusions, right? That means for what type of damage I'm not liable at all. But assuming the carrier is liable, because the carrier cannot prove that it was an exempting impediment, or because the cargo owner is able to prove that the carrier was negligent in not ensuring a seaworthy ship. What is the liability limit? And again, you have to read carefully the relevant provision in the original Hague Rules. It says, neither the carrier nor the ship shall in any event be or become liable for any loss or damage in connection with goods in amount exceeding 100 pounds sterling per package or unit. Per package or unit. Now the question is, what is a package? Or what is an unit? Package is relatively easier to understand when things are packed, right? But what is a unit? There was a famous American case in which a locomotive was lost. The American Limitation of Liability that implemented the Hague Rules in the United States, the Carriage of Goods by Sea Act, COGSA, provides a limitation of liability for $500 per package or unit. The court decided that a locomotive was a unit, and the owner got $500 for a locomotive that was lost under the American Carriage of Goods by Sea Act. The second question, and the reason for some unhappiness with this provision, is that it was adopted in 1924, and we'll get in a moment to the problem of the monetary unit chosen for it. But the notion of package was inserted there before the container. And after World War II, when the containers started being used first by the American military in World War II and then became part of world trade, the question arose, what is the unit under the Hague Rules? The container or the contents of the container? And the containers being sealed, you had contradictory case law. You had courts saying a container is a unit, and others say no, it must be each package within the container, right? If you consider the value of electronics and other goods are being shipped by containers nowadays, you can very easily have every package in a container being worth more than 100 pounds sterling, which is the liability limit there. This was one of the reasons why in 1968 there was this amendment to the Hague Rules, the so-called Hague-Visby. It was not the only thing that the Hague-Visby did. The Hague-Visby touched upon several points of the Hague Rules to modernize it. But one of them was, for instance, the Hague-Visby also introduced a provision to accommodate the use of containers under the Hague-Visby rules. But it also changed the liability limit from 20 pounds sterling to 1,000 francs. I would, in a moment, present a chart on an actual comparison of the values of these monetary ceilings. But one of the reasons for moving from pound sterling to the so-called 10,000 francs, which are defined in paragraph D of this provision as being a unit consisting of 65.55 milligrams of gold of 900 purity. This is the so-called franc carré, was a unit used in international treaties at that point in time. It's because the United Kingdom had abolished the gold standard for the pound. So now all of a sudden the pound of 1924, which was a gold standard pound, was no longer tagged to the gold. And the question that arose in the meantime was, what is 100 pounds? Is 100 pounds currency value today? Is 100 pounds currency value of 1924? Is 100 pounds the gold equivalent of 100 pounds in 1924? Is 100 pounds the gold equivalent of 100 pounds today? So you had then various understandings of that at that point in time that led the international community to come up with this new unit of account, which was then among the countries that ratified the 1979 protocol, then replaced by a more stable unit of calculation, that is the special drawing rights of the International Monetary Fund, because those are published every day, and you know every day how much an SDR is worth, and it essentially it is the same value as in the Hague-Visby rules. Is 666.67 units of account. It's not a very user-friendly figure, but it was the same equivalent in SDRs of the 10,000 franc per carré of 1968. The Hamburg Rules then attempted to raise the liability limit a little bit, and this is why they were not very popular also among ship owners, from 666.67 to 835 special drawing rights per kilogram of gross weight. By the way, this is also something that the Hague-Visby rules had already introduced, the calculation not by piece or unit, which was very confusing, but by weight, and also introduced a liability limit for 2.5 units for delay of goods. Now, the Rotterdam Rules increases very lightly the liability limit as compared to the Hamburg Rules, is to 175 units of account per kilogram per package or other shipping unit or kilogram, or 3 units per kilogram, and 2.5 times the freight for delay of the goods. So we basically have one liability per package or per weight, whichever is higher, and another system for delay. Now, very quickly, what does this mean? And that only those countries that have ratified these various conventions in their actual currency are using completely different limits. You have countries, for instance, that never ratified any convention, so there is no liability limit. The carrier is liable for the entire loss. For example, Brazil and Venezuela. Then you have those that have the 1924 Hague Rules, but invoke the 100 pound sterling value depending on whether it is the value of 1924 or the current gold value. And you see the variation, for instance, between Peru and Argentina. In Peru, that means $220. In Argentina, is $8,500 per package or unit. And then you go to those countries that apply the Hague Rules, but have, when they adopted the Hague Rules, they converted the liability limit to national currency, and then it goes from $135 in Ireland to $500 in the United States. Then you have those that apply the Hague-Visby rules, but only the package limitation, not the kilo limitation. That's the case of Germany. And those that apply the Hague-Visby, but in the 68 form, but not the 79 protocol, and so on and so forth. You see, there's a huge variation in the way this is actually applied in practice. It means that forum shopping in international shipping may well be worthwhile pursuing, because you may get very significantly different sums of compensation depending where you're suing. But the discrepancy is also not only between the various maritime limitation regimes, but also if you compare to other means of transportation, because under the original Warsaw Convention was 250 francs per kilogram. Then eventually, under the Montreal Convention, it became 17 special drawing rights per kilogram. We have 8.33 special drawing rights per kilogram or gross weight for road transportation, and we have 17 for rail transportation. Now, each of these regimes applies mandatorily because this law is mandatory. Now, if you have multimodal carriage, what happens? Then there is no international convention for multimodal carriage. There was an attempt in the 80s, it will never enter into force. It means that you have to provide a contractual solution, and the contractual solution that exists nowadays is a set of rules developed by the International Chamber of Commerce with the UN Conference on Trade and Development, UNCTAD, and the rules for multimodal transport documents that are incorporated in transport documents. Nearly all of the multimodal documents refer to them. And then they would say that the amount is the amount that is due under the law that mandatory applies to the carriage if you know when the damage occurred. So if you know that the damage will occur at the moment when the goods are in transit by road, you apply the road convention. If it was by air, the air convention. If that is not known, and they're often the case when the container arrives at the destination, open the container, the goods are damaged. And it's very hard to prove when the damage occurred. Then you apply a so-called network liability, and that will be, in the case of these rules, the same amount that will be due under the Hague-Visby system. Okay? These are rules that are chosen by contract in practice. Now, to have that in euro figure, and this is taking the value of the special drawing rights today, you would have under the Hague-Visby 24, if you take the pound value as 100 pound, means 130 euro per piece. If you take the Hague-Visby Rules 1968 version, it will be 799 euro per piece, or 2.39 per kilogram, and so on and so forth. You see increasing with the Hague Rules 79, higher in the Hamburg Rules up to 1,000 euro per piece and 3 euro per kilogram, and the highest being under the Montreal Convention and the quota for rail transportation being 20 euros per kilogram. So you see also that it also pays in litigation to try to establish exactly when, in which point of carriage the damage occurred, because then you'll be able to claim a higher limitation of liability than if you are unable to and you have to rely on the network cap of liability. A question was asked before, can we break the ceilings? Under the current conventions, this is not possible. You don't break the ceilings. You used to be able to break the ceilings under the theory, for instance, in the United States called quasi-deviation. For instance, if you transported the goods on deck, right, and the court would say, oh, but you had an obligation to transport them on dock. You are grossly breaching the contract, so we are not able to invoke the limitation of liability. That theory was invoked at that point in time to interpret the system in a fairer way to protect better the cargo interests. Nowadays, this is dealt with within the entire system, and that is why the conventions do not provide for the possibility of breaking the ceiling if the liability is one that is covered under the conventions. Of course, if the conventions do not apply, then you are in the realm of freedom of contract, and that will be a different story. But as long as they apply, the liability limits are mandatory. That shows how complex this area is. And this last lecture in this cycle also shows that the interaction between soft law and mandatory law, in the case, for instance, of multimodal transportation, where no mandatory law is available. With that, that concludes for today, unless we have any questions. Yes?
May I ask a question from the first part of our lecture? I have a question about bill of lading and the Seaway bill.
Yes.
So, what is the essential difference between them? Seaway bill just an issue of bill of lading, or there are like really big difference between them?
There are real differences between them, and I'm getting back to this image just to explain to you the usage in a moment. But a Seaway bill is a non-negotiable document. You cannot sell goods in transit with a Seaway bill. You cannot transfer the Seaway bill to anyone else. The Seaway bill is used mainly in the North Atlantic trade routes because of the one problem of the bill of lading in the past was that, and it's not only the past, it still exists nowadays in many areas of the world, that the ship might arrive at the port of destination before the bill of lading arrives, right? This would not happen, might not happen in the olden days when the ships would be slow and we have to be calling many ports. But if you're having a straight transportation across the Atlantic, it may happen that the ship would arrive at the port of destination, the bill of lading is not yet there. And then what happens? The ship has to pay a fee at the harbor for each day it stays longer than it had originally booked. That's called demurrage. And so there's a cost in that. And also a cost because the ship cannot start the next voyage on time, right? And then a practice developed, and there was a question about that in one of the, in another lecture, that the captain would then be asked to deliver without a bill of lading, which the captain is not supposed to. The captain can only deliver against the surrender of the bill of lading. Then the captains would be asking the consignee or the person who claimed to be the consignee, I delivered to you, but you have to give me a letter undertaking to indemnify the carrier against any loss or claim by a third party who claims to be the legitimate owner. So to avoid all these complications, in the North Atlantic trade, it became more common to use a Seaway bill because it is not negotiated. You are not using a documentary credit. It doesn't get to go through the banks. You just send straight to the. You don't even need to send it physically. The consignee just needs to prove I am the person named on the Seaway bill and I can claim delivery of the goods. So they are substantively different documents.
Thank you. Another question. Can bill of lading and Seaway bill be presented in electronic form to the captain nowadays?
Whether they can be presented in electronic form, well, the Seaway bill definitely. The bill of lading is a much more complicated thing. If it is a non-negotiable bill of lading, we heard from Professor von Ziegler the reference to the straight bill of lading. That's a non-negotiable one. It basically functions as a Seaway bill. In theory, you could say, yes, I can, because it's not negotiable, there is little risk, but still, it requires this physical surrender of the paper. But that's one that is easier to replace through an electronic form. negotiable bills of lading that are supposed to be negotiated give rise to a larger number of issues. The Rotterdam Rules contemplate them, allow them, but you have to have a mechanism to ensure that only one person is at any point in time in control of that document, able to make a disposition and give instructions on the basis of that. And that is not so easy. It works on closed negotiating platforms, but it's difficult to have that in an open system. Okay. So with that, then, thank you very much.